Good morning to everyone that's joined in the UK and Europe. Having a look at the people that were due to join, I think we've got some people joining from the Middle East and Asia, so good afternoon and good evening to you as well. My name's Mark Davison. I'm the Head of International Arbitration here at Mills & Reeve, based in our London office. And today I'm going to talk about the new LCIA London Court of International Arbitration rules, which come into effect as of the 1st of October 2020. I'm just going to briefly talk about what's changed and what you need to know. Just in terms of some housekeeping, this webinar is being recorded. It will be available afterwards. There'll be a follow-up email after the webinar with details of the recording. If you've got any questions during this webinar, please feel free to use the Q&A function. I understand it's all anonymous, and I'll try and deal with as many questions at the end. Also, please feel free to use the Q&A function as for any suggested topics that you would like us to cover within this in-house in focus series, and any feedback. After the end of this webinar, I understand there'll be a brief pop-up that pops up just asking for just your views on today's webinars and any sort of suggested topics that you'd like us to cover in future webinars in this series. So before I start to talk about the new LCIA rules, I appreciate this sounds incredibly cheesy, but it's something which I always try to cover off when I'm talking to people who are dealing with contracts on a day-to-day basis and are involved in the drafting of contracts. But it's always about when you're drafting a dispute resolution clause, whether you're looking to adopt an arbitration clause or a court dispute resolution clause, just to always have this in the back of your mind, which is just enforcement, enforcement, enforcement. And the reason for that is that I appreciate that when you're drafting dispute resolution clauses, it's always at the back end of a contract. It's usually the last thing which is thought about, but always just have in the back of your mind, if this goes wrong, how am I going to be able to enforce any judgment I get against the assets of a counterparty? And that's particularly important when you're dealing with counterparties who are based overseas or have assets based overseas. And it's probably the key advantage which is in arbitration's arsenal is something called the New York Convention, which is a convention which has been signed by more than 160 states around the world, which allows for the enforcement of arbitration awards around pretty much in most jurisdictions around the world. It's particularly topical at the moment, especially in light of Brexit and the fact that we'll fall out of the Brussels recast regime at the end of the transition period. I appreciate there's some people on this call that aren't particularly familiar or may not have used arbitration before. So just really quickly, all arbitration is, it's just a private form of dispute resolution. It's generally a confidential process that parties have agreed to in writing, either at the outset when they enter into an agreement or at a later stage where both parties agree that a matter should be referred to arbitration rather than to local courts. It generally leads to binding decisions on the parties. I'm not going to dwell much further on sort of advantages and disadvantages of arbitration and what advantages arbitration may pose in a post-COVID-19 and Brexit world. I did a session on that on the 23rd of July. There are details there on the slide about how you can access that, but I'll make sure that at the end of this webinar in the follow-up email that will provide a link to that. So if you're interested in just finding out more about arbitration and some of the advantages that arbitration may have, certainly when we come to sort of post-COVID and Brexit world, please do take a view of that webinar. So again, just very briefly before I touch on the new LCIA rules, just a quick recap of just what the LCIA is, who can use it, why use it. So basically, the LCIA, it's a world-leading arbitration centre. It's established in 1892, so it's 3 years older than even the English Commercial Court. Its role is purely to help parties administer cases. And as part of that, it has a set of arbitration rules which effectively governs the process for how a dispute should proceed. Generally, the LCIA administers about 300 cases a year. Statistics at its release suggest that it's the average length of a case before the LCIA lasts about 16 months. In my sort of experience of dealing with commercial court cases, I generally find they're about 18 months. So when people say that arbitration can be longer than general court litigation. I don't necessarily agree with that. I think really where arbitration may come to the fore is in a post-COVID world as well, given obviously that we're going to have backlogs in court cases that need to be administered, given the lockdown that's happened during COVID. In terms of who can use it, basically anyone who's seeking to resolve a dispute, but it's most appropriate for people who are involved in commercial disputes, which I suspect will be most people who are on this webinar today. In terms of sort of why use the LCIA, I tend to find that in comparison to other arbitration centres, such as the ICC, it's generally cheaper up front than those. It's more flexible than English court litigation. And also it's effectively what I was talking about before, the New York Convention. It's the fact that with an arbitration award, if you're dealing with parties who have assets based overseas or are based overseas, you've got a better chance of being able to try and force that award overseas than you might necessarily be with an English court judgment. So in terms of what's changed under the new LCIA rules, I'm going to focus on 7 key changes. I'm then going to focus on just 2 omissions which haven't been provided for within the rules. Basically, the new LCIA rules come into effect on the 1st of October 2020, so any arbitration that's commenced after the 1st of October 2020 will be subject to the new rules, unless parties have agreed otherwise that previous versions of the rules, such as the 2014 rules, should apply. I'm going to focus on some of the key changes more rather than some others, but I think effectively the first key change is about the summary assessment of claims. So basically there is now a clear mechanism within the new 2020 rules which provides tribunals with the powers to summarily dismiss hopeless claims and defences. In previous iterations of the rules, there was an implicit power which allowed tribunals to make early determination of claims, but it was generally, I found that tribunals were reluctant to exercise that power. Now that the rules provide an express power for parties to be able to apply for relief to summarily dismiss a hopeless claim, I think the general view in the market is that will be widely used by parties, especially in the context of those where it's a dispute about a simple debt claim. The reason the LCIA have made this change is to try and follow changes made by other arbitral centres around the world that have adopted similar express provisions, most noticeably in Singapore and in Hong Kong. And recent reports from SIAC, the Singapore International Arbitration Centre, suggest that it's already being widely used by parties there. The second sort of key change is just about data protection. So data protection has been a hot topic in arbitration for years. Generally, arbitral disputes are between international parties. Therefore, there's often flows of data from jurisdiction to jurisdiction. It's been common in recent years for parties to try and address data protection issues early within a dispute. Various arbitral bodies, such as recently ICA and the IBA, have joined forces to try and create a roadmap for how parties should deal with data protection issues within the arbitration process. And so what the LCIA have now done is they've provided express rules that the parties, the tribunal, and in certain circumstances the LCIA, need to consider at the early stage of a dispute appropriate data protection measures within the arbitration, just to ensure that there is information security measures to protect the information which is shared between the parties in an arbitration, and also in order to address the processing of personal data produced or exchanged in arbitration in light of any applicable data protection regimes. So it'll be interesting to see how that develops as parties get used to the new LCIA rules on data protection. In terms of a third key change, it's about electronic communications and technology. Basically, the rules now provide a clear instruction to parties that filings and communications should be made electronically. So rather than sending each other hard copy of documents serving arbitration requests, it should be made electronically. It also grants the power to tribunals to convene hearings in a manner that it sees fit, including by way of video technologies, if the tribunal considers that appropriate. I think that will be useful for parties that, certainly in the early stages of a case where there are interlocutory hearings, just to make sure that they can progress. Because obviously it can be difficult, even in normal times, to find a window when everybody can convene to a physical hearing place. But especially now, given the pandemic and the social distancing restrictions and travel restrictions on parties, the fact that if you can have certainly the interlocutory hearing stages heard virtually is likely to ensure that arbitrations commence much quicker. It's not only sort of a welcome development in terms of just the COVID-19 pandemic, there's also sort of a certain aspect that within the arbitration community, there is a push from us to ensure that our arbitration process is conducted in a climate-friendly fashion. And so actually there's a recent study by a committee that was organised by the Campaign for Greener Arbitrations, which recently estimated that if you just removed all paper bundles, courier and travel services from your average arbitration, that could save up to about 51,000 kilograms of CO2 emissions per arbitration, which, to try and put that into perspective, that's about 10 times the average carbon footprint of every individual in the UK. So again, if there is a bigger drive to ensure that more arbitrations are conducted in a greener fashion, then hopefully we'll be doing our bit for the environment as well. Just very quickly on timing for awards to be issued, the 2014 version of the rules just provided that tribunals should issue their awards as soon as reasonably practicable following the last submission of the parties. The 2020 rules now provide that the award should be made within 3 months of the last submission from the parties. In effect, I don't think that's going to make much difference. Ultimately, an award takes as long as it takes to draft, but at least it's a clear direction from the LCIA that tribunals should get on and make their award as soon as possible. A useful change within the 2020 rules is about what we call composite requests. And basically what this means is if you've got a dispute with a party or with a chain of parties, but they fall under different agreements, under the 2014 rules, what you would have to do is you would have to file an arbitration under each contract for each dispute and then apply for those to be consolidated together. So effectively you'd be paying a filing fee per arbitration, and then you would apply for those to be consolidated into one reference, into one case effectively. And there was a party in A and B that got unstuck where they had a dispute under 2 separate agreements and filed one arbitration for both agreements, and then got unstuck on the basis that no 2 arbitral references should have been made, so 2 arbitrations should have been filed. And so what they've done under the 2020 rules is they've provided a mechanism that if there is a dispute under multiple contracts which are connected, one arbitration reference can be filed, and then it will be up to the tribunal or the LCIA to determine whether it's appropriate for those disputes to be heard as one arbitration case. So that's a welcome development for parties, especially those that are dealing in supply chains or in construction contracts or IT contracts where you have multiple parties, that there is just a clear regime there for the consolidation of disputes into one reference. Just the use of tribunal secretaries. This is more of an academic point really for arbitration users, but it's been a fairly hot topic in arbitration in recent years. And basically, all tribunal secretaries they're used to take administrative tasks. Generally because they're younger lawyers usually who are seen as having more time on their hands to be able to undertake the administrative tasks within an arbitration, not actually to decide the case or take any substantive steps in the case, but just to administer the case, just to improve efficiency and also reduce the costs that parties may incur in senior tribunal members undertaking those tasks. But there's been reports in recent years that there's been an inappropriate over delegation of certain matters to tribunal secretaries. And so the arbitral community over recent years has tried to take steps to provide frameworks of how tribunals should work with secretaries. And there is now a clear guidance within the 2020 rules about how tribunals should use tribunal secretaries if they're adopted within an arbitration. Very finally, just in terms of fees, it's just to mention that the filing fee under the 2014 rules to file an arbitration was £1,750. It's now gone up to £1,950. Again, if you compare that to the English High Court, where generally for cases that we'll deal with, the filing fee will be £10,000. It's obviously cheaper to file an arbitration, but obviously within that, you have to pay for the tribunal's fees. And the maximum that an arbitrator can now charge has gone up from £450 to £500. Just in terms of sort of what I call sort of two key omissions that has been missed within the rules. The first is just to clarify a particular point about emergency arbitrators and the ability to get injunctive relief. So basically what happened about 10 years ago, most arbitration centres around the world have adopted what particular regimes to allow for emergency arbitrators to be appointed. And basically the idea of an emergency arbitrator was to allow parties the ability, if they needed injunctive relief to protect documents or to protect assets, they could apply to the arbitration centre that they had their arbitration agreement with, ask for an emergency arbitrator to be appointed to make an interim award in order to provide the relief that you needed. There was a debate in the market as to the ability to enforce those interim emergency awards in particular jurisdictions. And so basically parties wanted the ability, well, I can either go to my emergency arbitrator or I'd rather just go down to court and get a court order in support of the arbitration process. So under the English Arbitration Act, it's under Section 44, you're able to go down to the English court to get injunctive relief in support of the arbitration. And so in the 2014 iteration of the LCIA rules, they adopted this emergency arbitrator regime. And then there was some confusion caused by a case called Gerald Metals and Timmis in 2016, where a party applied for injunctive relief in support of the arbitration process that had applied to court. And the court refused to provide the injunctive relief on the basis that the parties had the ability to get such injunctive relief from an emergency arbitrator under the LCIA rules. And so I think everyone in the arbitration community expected that there may be rules clarifying that situation within the 2020 rules, which hasn't happened. And so effectively, I think what parties are going to do is they're going to continue what they were doing post Gerald Metals and Timmis, which is if they want it to be clearly expressed between the parties that they've got the ability to go to court to get injunctive relief, then they'll provide for that within their arbitration agreement itself. Just another interesting omission within the LCIA rules is just about expedited procedures for small claims. So a lot of international rules recently have been providing that disputes of a certain value will go into what they call an expedited regime. So I've just given two examples there of the ICC rules and then the Singapore rules, which provide for expedited determination of small value claims within 6 months, generally within 6 months of the first procedural meeting, which happens quite early on within the dispute. The LCIA hasn't provided for that within its rules, but again, it doesn't stop parties from agreeing that their dispute should be resolved in an expedited regime if they want to. You can either do that up front within the contract, or you can do that later on once the dispute has formed and you want to take the matter to arbitration. I would just provide some sort of, just in terms of a small war story, I've heard examples of somebody agreeing that any dispute will be resolved within 6 months in their arbitration agreement. And then it turned out to be quite a complex dispute with a estimated quantum value of $700 million. And trying to get that resolved within 6 months provided a bit of a headache for the parties. So just have that in mind if you're thinking about that within your arbitration agreement. So that's really a quick canter through the changes that have been made to the LCIA rules. Just finally, just want to just spend a minute or two just about arbitration clauses if you're interested in adopting an arbitration clause in your agreement, just in terms of just some top tips there, just to make sure that they're not missed off. Um, Again, most arbitral institutions around the world have got model clauses which you can adopt from their website. But just in terms of top tips, just to make sure that you make sure these are covered off within your arbitration agreement. What I mean by the seat of the arbitration is effectively what city and country you want your venue of the arbitration to be. And generally that will apply to what procedural law will govern your arbitration process. It's quite important if you're going to select London, it's important to say London, sort of England and Wales, don't just put UK, because then there's uncertainty there as to whether you mean Scotland or England and Wales, for example. So just say London, England. In terms of numbers of arbitrators, it's generally cheaper to appoint one arbitrator. So just have a think that if you think your quantum value is going to be less than, say, £10 million or £50 million, do you really want to pay for 3 arbitrators when it'd be just cheaper to have one arbitrator? Just in terms of the 6th point there about nationality provisions, basically this is the LCIA rules and certain other institutional arbitration rules around the world provide what they call nationality provisions, which means that if you're, say you're a UK party and you're dealing with a French counterparty in a dispute, then the LCIA rules say that tribunal can't be a person of a nationality that's same as the parties. So in that case, you would have to find a non-British or non-French national. If you're both UK parties, then it's fine. You can have a UK arbitrator, but it can create headaches, especially if you're a UK party dealing with an international counterparty, but your contract is under English law. So ideally, you would like an English arbitrator. So it's just something to bear in mind when you're drafting your arbitration agreement. It's just a very quick canter through arbitration clauses. If you're in doubt, we're more than happy to assist. I've provided more details about drafting arbitration clauses in the webinar that we ran on the 23rd of July. So please do take a look at that. Again, we'll make sure to follow up after this webinar with a link to that session as well. So that's all I had to say today, which I hope has been useful. Just in terms of questions, so there's one here. Just, is arbitration cheaper than court litigation? It's a sort of a vexed question. It's I think the general view was previously, sort of going back 20 years ago, that arbitration was cheaper than court litigation. I think that view has sort of changed over recent years, that people start to think that arbitration was more expensive. Generally, I think it's around the same sort of price because it is a more flexible regime. The disclosure obligations are less onerous than under court litigation, but then at the same time you've got to pay for the tribunal fees. But I think generally the costs are comparable. I think that's all we've got in terms of Q&A. So thankfully we've wrapped up within the 30 minutes. Oh, sorry, there's just one more. Is there a list of seats of arbitration available for selection in agreements? I mean, it's really up to the parties where they want their seat of the arbitration to be. So you can have it anywhere around the world. Generally, however, parties will look for an arbitral seat which is commonly used for arbitration, just because that jurisdiction will have more experience of dealing with arbitral issues. So if there are any applications which need to be made to the local courts, there will be a system of law which is made in respect of, sorry, there will be legislation about the arbitration process. The courts will be used to what arbitration is, and so therefore they'll generally be more supportive of arbitration. So the UK, for example, is seen as a pro-arbitration jurisdiction. Similarly, in other jurisdictions, so New York, Singapore, for example. I would look to those types of jurisdictions where it's common for for arbitration issues to be determined by their courts when looking for where to have my seat of the arbitration. Generally, if you look for where the arbitration centres are based, then that will give you a good guide as to whether or not those courts will generally be supportive of arbitration. There's another question here. Just if did you say if I'm a UK counterparty and have a German supplier, the language of the arbitration must be neutral? No, sorry, it's the nationality of the tribunal. So if you've not disapplied the nationality provisions within the LCIA rules and you're dealing with a German counterparty, then it's likely that you're going to have to select a non-UK national within that arbitration. Perfect. That's all the questions, so we're still done within the half an hour, which is great. Just very briefly, just to let you know about some upcoming in-house in focus webinars. So we've got one next week about the SRA's new standards and regulations, and then we've got one the week after about planning update. If you'd like more details about those events, they're available on our website. Again, I'll make sure that they're included within the follow-up email that we send with the recording of this webinar. And very finally, when you exit this webinar, hopefully there will be a pop-up which pops up, and just to provide some feedback today about any thoughts you've had about this webinar and any particular topics that you'd like us to cover off in this in-house in focus series. All the feedback is greatly received, and it just helps us to be able to better streamline the webinars that we deliver in the future. So thank you very much to everyone that's attended. I'm Mark Davison, the Head of International Arbitration here at Mills & Reeve. If you've got any questions, then please feel free to contact me. My contact details are there on the screen, and we'd love to hear from you. Thank you very much.